So, good morning, all of you. Thank you very much for joining this Sunday. Today we have our esteemed guest, Mr. M.A. Ganapathy. So, he'll be talking about the global aspect of data privacy and AI. So, he'll be sharing his experience, like practical experience. He's having a more than 2 decades of experience, and he's a legal counsel at Digital IP Technology and Climate. So, he's a accomplished legal counsel with the 20 years of expertise in digital IP technology and climate sectors, unique combination of legal, technical, and business qualification with specialized knowledge in emerging technology, intellectual property, data privacy, and environment compliance. Proven track record in managing complex legal framework for multinational companies, including Shell and SABIC. Adept on navigating the intersection of technology, innovation, and environmental sustainability through strategic legal guidance and risk mitigation. So he's having core competency in digital and technology law, IPR, climate and environment law, data privacy and GDPR, cybersecurity, international trade law, competition law policy, carbon taxes and sustainability, ethics and corporate governance. So presently he's working associated with as a legal counsel at DGIP, the legal solution for emerging tech company. Before that, he also worked with Shell and then various other organizations like SABIC Research and Technology Private Limited, NATCO Private Limited, you must be aware about. He has on having degree of LLB, LLM, MSc Chemistry, Master of Foreign Trade and MBA. So with this brief introduction, we welcome you on behalf of organizing committee for today's session and request over to you to enlighten our participant. Over to you, Mr. Ganpati.
Yeah, thank you very much for that beautiful introduction. And yeah, I thank all the participants. That too on Sunday morning, I could see 27 participants. Okay. So today we are going to talk about one emerging area like artificial intelligence and data privacy and data protection. What are all the legal and regulatory issues around that? So I had prepared two presentations. Shall I share my screen and walk through it?
Yes, please. Yes, yes.
Can you able to see my screen?
Yes, yes, yes.
Yeah, first the two topics. First, we are going to talk about data protection and its legal and regulatory issues. Then we will go to artificial intelligence. So we will touch base upon what are all the legal requirements for data protection and how the law and legislations have been evolved. So, as of now, over the globe, more than 160 countries have implemented data protection regulations because of the changing, evolving technologies and data transformation which are happening around the globe. So, we will see in 1970s in the world, the first data protection laws has been emerged in Europe, US, and other countries. And during 1990s to 2000, because of this digital revolution, there were internet growth was predominantly there, which requires a robust protection for privacy because of this privacy concerns. Like at the time, this Facebook and social network, emails started emerging. So some sort of like individual person's privacy needs to be protected. So before going further, further, like I will ask one thing, like you may be knowing what is the main difference between data privacy and data protection. So data privacy means as a private person, how I can control my information, whether I am giving consent to my information, whether I have given, whether the other person who is using my data, whether they are using it properly or not, whether I have subsequent controls for using my data. Whereas data protection involves like what are all, how the data is governed, like access control, what are all the standards which require to control the data. So it is good to have an understanding about the difference between data privacy as well as data protection. So in some countries, data privacy laws exclusively how an individual protecting his privacy, how it is happening, and all that laws are evolving. In some cases, overall comprehensively by using what kind of tool, technology, and all that data protection being governed. And subsequent between the third generation, 2010 to 2020, uh, global digitalization like internet and all that has been evolved further, and then comprehensive law has been evolved in many jurisdictions. And then now the artificial intelligence and other emerging technologies has come, so which focus more the data being going from one continent to another, cross-border transactions has been available. So further rules, legislations are not development. It is an evolving process. We can't say that this rule is standard. This rule is we can use it as standard like that. Oh, but of course, GDPR is one of the standard legislation which come from Europe. Yeah, we will go in depth in the subsequent slides. But as I mentioned, the overall for data protection, these are all some of the matters. Like whichever country it may be, it is a social contract between the data provider and the data user, whether they are handling the data ethically, how they are handling, whether they are misusing or not, like that, some of the aspects need to be different. And then if we consider at an average 6 trillion cyber crimes, which is happening due to this data protection area, like there is type of data protection or data privacy and all that. Then one more matter which concerns this area is business trust. If you have a robust data protection mechanism, business to business, business to consumer, business to customer, all the verticals will be having trust on the company. So they will do more business. And then ultimately, as we mentioned earlier, individual data privacy concerns, individual rights, which is having in India and other fundamental rights, protection of fundamental privacy rights. So when we look overall worldwide, as of now, around 137 countries having some sort of laws which protect data protection. Then when it comes to African, 61% of the regions have adopted some sort of legislation or framework or regulations like that. And then in Asia, 57%. And then in lower developed countries, around 48%. This is one of the like United Nations website, which provides if you select a country, in that particular country, what are all the data protection and data privacy legislations, what are all the regulations and all that. If that is not available, it is mentioning no legislations available. If it is under evolving stage, if the legislation is under drafting stage, it is providing very good information. Like as on date, up to date information is available in this website. And we can download it and we can compare it with various jurisdictions. So just I had put a screenshot of That's for your personal use. So when we talk about data protection laws, irrespective of the countries, almost all the countries having certain core principles by which the law and legislation or regulations are evolving. So we will see some of them. Like whatever the data it is, like what we need to collect first, minimum data needs to be collected. What is necessary, that alone needs to be collected. And then purpose limitation. For what purpose you are collecting a data? If you collect the data for single purpose and use it for some other purpose, it is like, ethically not correct. And as I mentioned, individual rights, like you need to provide or the company needs to get consent from the user, informed consent, like they need to provide for what purpose they are collecting the information and whether the data subject is giving agreement to process the data. So that is consent is one of the principle. And then security. The other party who is collecting your personal data, whether he is taking adequate measures to safeguard it by data protection tools or other mechanism, that is very important. And then how the individual rights are protected, like for access to the data, correction of data, erasure, like forgot, like after some time, right to forget or right to erase the data because there may be some like errors in the data may happen. Sometimes you, after certain period of time, you need not want to have the data with the third party. So those rights, the individual can have the authority to exercise. So that is one of the core principles. Then the transparency, how the data being handled, how the collection and use of the data by the other party. So these are all the common principles which is applicable in almost all domains. Then, as I mentioned, the European Union, we can say this GDPR, General Data Protection Regulation, as more or like a standard framework. So, which is a model for other countries. Like many countries are replicating the essential patterns of it. For example, Brazil, India, California, and other countries taken some good finer points from GDPR regulations. So it is having a global impact also, like because of this enforcement. Then the law says that there are hefty fines and then penalties, which goes up to 20 million euros or 4% of global annual revenue of the company, like that. And then, as I mentioned, like it is providing a comprehensive rights for both the parties, like right to forgotten, data portability, breach notification. It's very comprehensive legislation. So these are some of the essential compliance which are required in GDPR. Legal basis. Consent must be explicit and specific. So whenever any data subject is giving consent, it will clearly mention for what purpose after understanding the subject providing consent. And then this GDPR is evolved around six major principles, which we already seen, but we can say 6 plus 1, 7. In subsequent slides, we will go through in depth what each principle says. And then this GDPR contains as a complaint mechanism, data subject rights, how you can access to personal data, how you can give concerns, and how you interpret the notices, and then how you can rectify the errors or inaccuracies, and then in case of any errors or any typos, write the erasure. Like after something, if you find, for example, in some of the public data collection point, your name may be initials may be wrong, your surname may be having a error in the surname. So after some point of time, if you do not have the capability or authority to correct your name, initials, or anything, that may not be a proper data collection mechanism. So your rights be violated there. So if you have a easy and workable solution for that, that would be very helpful for the data subjects. And then in case of any violation, there is a specified time period for addressing it. For example, GDPR is having 72 hours notification in case of impact or violation or any breaches. And then how you enforce the GDPR compliance. So there are well structured enforcing authorities, for example, data protection authorities, and then it is having robust coordination with enforcing authorities, with legal, police, judicial, and other regulatory mechanism. And ultimately, how you enforce it, how the fines, penalties been enforced for non-compliance of the law. So as I mentioned, there are six principles, but we can add one more, six plus one. So it is, as I mentioned, it is a comprehensive framework. It is focused on citizens' privacy rights so that data privacy can be governed. And then there were earlier also many individual legislations in Europe. So this directive GDPR consolidates all that and come up with a single unique legislation. So some of these key principles we can segment it into four main category also: integrity and security, purpose limitation, who is accountable for enforcing it, how the overall the framework is governing lawfulness and fairness, on what legal basis this GDPR has been evolved. Exactly. So this put it in the rights granted by what are all the rights as a subject you can adopt this GDPR. Right to object, restrict how your data is processed, right to portability, like how your data is can be portable. For example, if you have two different, if you want to portable your SIM, I'm just telling for an example, or you have a bank account with one bank and you want to transfer your account to other bank. So the portability means from one bank, the authority will transfer all your data to the other bank without much hassle. So the duplication will be avoided and all the data without any error during transfer using certain techniques, all the data when it transferred to other, that is called portability. So when it comes to companies, cross-border transfers may happen. Huge volume of data from one country to another. And the data subject having all the rights to request the portability or to stop the portability. And then right to erasure, right to access. So these are some of the individual data privacy rights. And as I mentioned, let us go one by one all the six principles. So this principle revolves around lawfulness, fairness, accuracy, and all that. So this needs to ensure the data which was collected, which satisfies the legal and regulatory of each country. And one of the basis is whether the data collected is based on lawful requirement. If suppose in a country having two or other different kinds of law, whether one law is overlapping other law or whether any difference or deviation in law is there, whether your particular collection mechanism satisfies the overall requirement, that is lawful collection. Then whether the data which collected is fairly processed or not. It must not be unduly detrimental or unexpected or misleading to the data subject. So they are collecting your data for one purpose, but using for other purpose should not be there. It should be treated fairly. And whether the data collecting concerns, whether they are processing your data transparently, like by informing how they are handling your data and what they are doing with your data with open, honest, and ethical way. So these are all some of the basic principles which govern by GDPR. So whenever the third party or business is handling your data, if you see some of the applications, there will be at the end of the application there will be a privacy notice. So that notice is a document which provides to the customer how the company is handling your data. So it is one of the legal requirements. So there are various kinds of privacy notice. With the company which collecting your data is having a responsibility to explain to the customers how they are handling your data. And then purpose limitations. Like as I mentioned earlier, they used to collect data, your personal data, only for specific purpose. If they want to use for some other purpose, they should get your consent. For example, when you join your company, you are giving to your company or your personal data. Suppose if the company wants to use it for some other purpose, for marketing purpose or identifying certain tracks or certain patterns out of your data, without your consent, if the company is handling, so that is it is not ethical. So they should clearly demonstrate accountability. Suppose in case they want to use your data for any new purpose, after specific consent is getting from the subject, they can use it. In GDPR, there are some full freedom is given for data to have archived after certain period of time, the data can be archived. And if it is used for any public purpose, for any scientific research or historical research purpose, it is not a violation. And then data minimization is also one of the requirement. Whenever you collect data which is very minimal or what is required. For example, during course of time, we also send many surveys. So during survey, we must ensure that essentially, like for example, name, age, date of birth, we did not ask for any sensitive information. What is exactly required? That minimum data only needs to be collected. Because holding more than what is required, not acceptable under GDPR. And data should be what you are collecting and what you are holding the data should be accurate. And you must, that company or the business should ensure all reasonable steps to keep it accurate. If they found out either subjects or the data handler identify if there are any error or incompleteness or inaccuracies in the data, they should strive to clean it up and make it proper. And then storage limitation. This is also one of the principles. So when they collect data, you need not hold the data for 100 years or 200 years or like many more years. In business scenario, many companies having data for many years. But after the GDPR and for example DPDP legislation and all that, law will enforce time period for data retention. And also we will like for example intellectual property patents and all that having a life period of 20 years. Financial data means 14 years, 7 years, like that. Depending on you can have an internal retention period for different types of data like HR, finance, research and development, scientific data like that. So after that period, you can erase or delete the data using suitable mechanism. You can destroy the data. Then whenever you collect the data, it should be like having integrity and confidentiality. Like in cyber security also, you may be knowing CIA, confidentiality, integrity, and availability like that. So that is one of the main concern to overcome risk. So appropriate technical and organizational measures will help to keep the personal data secure and confidential. So whenever any time you want to access the data, if there is lack of integrity means like you may not get the proper data. Data may be lost. If there is no confidentiality means third party can access it and which is determinant to the organization. So these are some of the important principles and requirements which can be audited by legal and risk assessment. So many companies having who is handling this data having legal and regulatory assessment, which is having a questionnaire format, which is mainly dealing with intellectual property rights, confidential technical information, competitive sensitive information, how the records are handled, records management, then whether it is complying with the trade compliances, trade controls, because some data when it goes to countries which are sanctioned, it should be followed before sending the data. So high risk countries, low risk countries, like that, it can be done by a risk assessment. And appropriate mitigation controls can be in place. Then more than six, the which we can add over and above is accountability, which refers how the company is taking steps for handling this above six principles. This can be done by either privacy notices, then training to the staff, like awareness, knowledge awareness, then controller processes contracts, then having regulatory complaints mechanism, like internal policies, internal procedures, and then privacy impact assessment, as I mentioned, data privacy or data protection impact assessment like that. And then monitoring by using tools and techniques, event logging, data breach records and all that. And then over and above, each company can have data protection officer. So in India also after this DP Act comes into force, I understood it, each company should have one data protection officer to look into data governance. And then the companies can use security standards like ISO 27001, which can provide, give confidence to the third party or customer that they have the commitment by the company to safeguard the data. So now we had overview GDPR legislations and European legislations. Now we will see how United States is handling. Because in United States, there is no overall single legislation, like unlike GDPR in Europe. So it is like fragmented. So they have multiple regulations, multiple laws like that. But overall, the Federal Trade Commission, which is having enforcement mechanism for data protection, they have the authority to act, to enforce, but there is no comprehensive federal law covering all of United States. So we will see some of the sector specific, like for example, if there is healthcare, that HIPAA, HIPAA, Health Insurance Portability and Accountability Act, which more or like sensitive personal data. Then when it comes to financial data, GLBA, then children online data. So if you want, all these are like acronyms. You can Google it and identify it what is the full form. And then state level legislations, like for example, California having strong California Consumer Privacy Act, California Privacy Right Acts, like that. And then, but the company who is working on United States having some challenges to integrate this data privacy and data protection. Then, since this presentation, we are handling global data privacy and artificial intelligence legislations. Like we will not dwell in depth. Overall, we will see how it is evolving, what are all the laws. When it comes to Asia Pacific region, China is having personal information and protection law, which is like a few years back, 2021, it has been implemented. And then they have a very strict data localization. All the collection data, they should have a server in their jurisdictions. And in India, like as of now, the framework has been enacted, and then recently, digital personal data protection rules come for public domain for getting inputs from the public. So once the rule also comes into force, we will have, like hopefully within the next few months, we will have a robust DPDP law as well as rules. Then similarly in Australia, having an established framework complying with global standards. But of course, there are challenges because many individual countries like Singapore, Hong Kong, and all that having various data protection laws and mechanism. Then when it comes to Latin America and Africa, Latin America having, for example, Brazil having legislation in compliance with GDPR, Argentina, Mexico, Colombo having some or other form of data protection mechanism, and some of the Latin American companies having the European Union adequacy decision. They have an agreement. So which determines if a non-European Union provides a level of degree of protection compared to European Union. If the European Union satisfied that this country is having adequate protection, then they will ask for transfer of personal data without any additional safeguards. Though you do not have any strict or stringent legal framework, but if you can convince them with legal and regulatory assessment or privacy impact assessment based on some comprehensive assessment, then you are entitled to invoke this EU adequacy decisions for transfer of cross-border transfer of data. And when it comes to African countries, some countries like South Africa, Kenya, Nigeria, having some or other sort of legislations. Then there are international organizations which frame standards and framework. For example, OECD guidelines. Then, as I mentioned earlier, ISO guidelines, ISO 27001, which is providing like guidelines for privacy information management by putting certain standards. And then certification for privacy program compliances. Then APEC framework, Asia Pacific Economic Commission is having cross-border transfer rules for facilitate easy transfer of data. So there are various forums also available apart from these guidelines and standards. The 130 plus data protection authorities, which is helping to provide inputs. So some of the main challenges are when it comes to transfer of data from one country to another, which is having different legal requirements or compliance requirement, there are challenges which we discussed. But how we address the challenges, as I mentioned, adequacy decision, which is already in place, and then there are standard contractual clause. When you transfer your data from one country to another, you can use this particular classes and terms which are pre-approved contractual terms for adequate safeguards in protecting your data. And similarly, binding corporate rules. There are internal company code of conduct rules which can be approved by the regulators, which can be used. For example, like the company which I worked with earlier also having headquarters in Europe, which use this binding corporate rules. Whenever any dealing with third party, they will include in all the contract standard contractual clauses as well as binding corporate rules. And then data transfer agreements. How the third party using your data will be. There are standard templates available. Okay, apart from this, when it comes to data, some of the special categories, how you handle the financial data, which involve like fintech companies are using many financial data, banking and payment information system, which are highly strictly regulated, which may handle like in India, PAN number and other sensitive data. Then biometric data, which are using face, fingerprints, eyelids, and all that. So biometric information will come under sensitive personal data. And also all the information which relating to health, that is also can be considered as sensitive personal, the caste, the political affiliations, your belief system, your health records, these are. And also when it comes to children's data, many countries are very strict, like age restriction below 15, below 14, below 16, like that. So when they want to start any Facebook account or any account also, you may notice that less than 14 years or 15 years cannot having access. But normally children used to put some figure and then log in. But there are consent and safeguard in place for parental consent when child wants to use or the child's data is used by the company. Yeah, as I mentioned, there are 20%, 20 million or 4% global revenue is fine for non-compliance. And then some of the mechanisms for compliance is having data protection officers, breach notification, and then having impact assessments like that. But then overall, when we see 22 million, when there is any violation or anything, this slide provides just a fee, like British Airways having a fine of euro 22 million for breach in penalty. Then Marriott has faced a penalty of 20 million euros for security incident, and then failure to report within 72 hours breach reporting, that also invites huge penalties. But then, though these legislations are there are challenges in enforcement, as I mentioned, how the concerns being managed, whether you are using any tools, how the records are managed, because consent may change over a period of time. Now, today you are giving consent, tomorrow may not. You can revoke the consent. Then cross-border transfer, like international, with different countries having different legislation. Because, for example, countries like China and Russia may ask for data localization. So you need to have separate servers in their domain. So how you handle those situations? So these are all the practical challenges faced by the project managers who are working on the huge volume of data. And then due to the evolving emerging technologies like artificial intelligence, and then big data, then this cloud computing and all that, how those things, the innovation, the emerging technologies play in this area. Then the final conclusion is that we need to have a global standard for model data privacy for global. Like for example, when it comes to intellectual property rights, WIPO, World Intellectual Property Organization is there. Similar to that, some global media can be there, regulating body can be there. Then some individual companies which can implement proactive policies by regular audit, some standards and all that can be. And then at the end, if we follow all these things, we can build trust through transparency and which will give more customer loyalty and at the end, business can thrive. It is advantage for business. Then now we'll have a brief look at the Indian digital personal data privacy law and rules. So just in 2000, January 25, the rule also ready. But in few months, we can expect data protection law in India. So it scope covers even foreign entities which are processing data of Indian residents. So when we compare Indian data privacy law, which is in comparable with GDPR, it is a balanced approach protecting individual rights, enable data use for economic and development of the country, as well as the business point of view also. There is no much cases for the business at the same time protecting individual rights. So these are all some of the key definitions which are in Indian legislation, which is subsequently differ from GDPR because GDPR put data subject as one of the definition, but in India we are using data principle. Then equivalent to controller, we are using in India data fiduciary, so data processor on behalf of a data who is processing the data, which is more or less same. Then extraterrestrial scope, which is also more or less similar to GDPR. So in short, core data processing requirement, which is more or less overlapping with the global requirement, storage limitation, purpose limitation, notice requirements, safeguarding with the safety and security feature, which is data protection requirement, then lawful processing, and some of these rights of the data privacy rights, right to information, right to correction, right to erasure, right to grievances, like escalate to data protection board for seeking effective resolution. So these are all some of the highlight of Indian law and some of the obligations for the organization who is collecting and processing is data protection officer. As I mentioned, if anybody of some of you or if we study certification, BSCA is providing certificate data privacy as a data privacy professional. So which they are also DSC also coming with data protection officer certification. So in future, I foresee some demand in those areas and data audit, regular data audit is one of the requirement, and then annual requirement for significant fiduciaries, then record keeping and clear management of records, governance of records, then how the individual companies are managing the concern, and then children's data, handling children data by verifying the age, parental consent, and all that. And then Indian law also the penalty can reach up to 250 crores. And then there is strict accountability in handling the grievances for complaints. So if you see, then this is the concluding way, this aligning with the global trend and aligning with the global complaint strategy. And since India is evolving as a global player, we are balancing the innovation with evolving technologies and evolving the volume of data which we can develop in future, and which we foresee helpful for business and economic growth of the country. So some of these traits are some of the requirements like regular training and awareness program, and then classification for mapping the data and all that. This will give a balance for legal regulatory compliances. So quickly we have seen data privacy, and now we can look into global overview of artificial intelligence also, because both are overlapping. Though both are a different subject, data protection, data privacy, we can handle the data privacy and data protection for artificial intelligence also. So we will quickly see what are all the global framework, what are all the landscape, what are all the regulatory approaches, and being an emerging technology, how India is evolving and how we can cope it up. But one thing before going further, like since artificial intelligence, there is no structural legal and regulations I could foresee, but there are certain frameworks which are available. We will see how it is evolving. So before that, many of us, like to my knowledge, the participants also coming from different background. Basically, I am not a technical computer person. I'm from a legal and science background. So we'll have a glimpse of what is artificial intelligence, what the definition says. So the definition says that what it mimics human cognitive functions through computation, algorithms, and data analysis is a definition of artificial intelligence. So when we see what is a cognitive function, it involves how our mental processes, such as how what we perceive, the perception of an individual, then the attention. When we see what we perceive and what way we give the attention to what a particular thing, and then what we learn from the attendance, and then what we are remembering, and based on all these things, how the cognition reasoning it. So when all these some of the factors when we put into a cognitive function, that is an artificial intelligence. Like vision, speech, and understanding what is going around the world. Then, over a period of time, what the learning and reasoning modern AI can interpret by that data pattern, and it itself draw conclusion, and then it itself continue to evolve by the cognitive factor what it learned earlier, and then continue to improve its own performance. So some of these are all the evolving technologies. As I mentioned, cognitive, perception, sense, comprehend, and act. And applying it to AI technology, some of the technologies are computer vision, audio processing, then after comprehension, natural language processing, knowledge representation, and then how it is acting, machine learning, then the expert system. And then we will see some of the solution based on this artificial intelligence, some of the solutions are virtual agents. Like now the AI agents, if we give a prompt, it itself do the work on behalf of us. And then based on identity analytics like iris or fingerprint and all that. Then there are cognitive robotics based on the, as I mentioned like earlier, it itself in auto mode can work. Then speech analysis, the recommendation system, like if itself and if you give a scan of health record, it will recommend this could be this, like that after scanning, after identifying. Then data visualization, it will present the overall management information in a pictorial form, that Power BI and all that is some sort of. Now we will see how historical evaluation of AI. In 1950s, with Alan Turing, he is the father of computer technology. One of the main turning point is the Turing test. So it is a test for machine intelligence as proposed in 1950. It is its main a cornerstone for artificial intelligence research. It proposes the way to determine if a computer can demonstrate human level intelligence by passing test of natural language conversation. So that is one of the starting point. Then between 1980s and 1990s, expert system emerged, like artificial intelligence. Here is some slack for a limited progress in that field. Then again, 2010, this deep learning revolution has started, which a paradigm shift. Then this AlphaGo, if you see, it is a computer game kind of thing which defeats world championship. So it is a Chinese game. So it is very complex. By development of the deep learning technique, this AlphaGo is a Google background is there. We can Google it, AlphaGo, and identify how the deep learning has worked on it. Then, when it comes to this 2020, the generative AI model like ChatGPT and all that come, and then artificially like image development, DAL, E, transform creative field also, like the intellectual property, like how the intellect can be embedded in artificial intelligence and how it rapidly progress by machine learning and all that. So, in short, this particular slide is a simple figure which represents artificial intelligence to machine learning to deep learning. So, the machine learning is the ability to learn without being explicitly programmed. So, you need not individually program the algorithm. And then the deep learning technique is a technique wherein by implementing the machine learning, it automatically using some of the artificial neural network, some of the concept it picked up by layer, it's developed further. So for a non-technical people, this particular slide can be used. With deep learning, with from artificial intelligence to machine learning to deep learning. Now we will global level how the artificial intelligence being adopted as of now. The 78% of the global organization as of 2025, like mainly the Fortune 500 companies and all that, out of which 75%, 78% is adopting in some form or other. When it comes to 2023, the adoption level is 72% to 78%. So, and people are expecting 35% growth in implementation. If you see a huge steep rise in market size of artificial intelligence growth. And these are some of the key technological area and application. Because once we understood this, then we can visualize and focus how the legal regulation and compliance can helpful in applying the AI field. So some of the things are like machine learning platform which are used by algorithms and learn from data. And then computer vision like, is focusing and the image can be interpreted on its own and then it will provide and understand and provide visual information. Like for example, CCTV camera is picking up various images. Then this computer vision can interpret it and alert you. Even before any incident happens, the machine learning can find it and provide auto alert. Then this natural language processing. This technology can enable machine to understand human language. In future, there are possibilities that there may not be any requirement of specific computer language. The natural language processing itself can understand. Then other application is autonomous system. You can see that autonomous cars, self-governing machines like robots and all that can do repetitive nature of work by itself by the application of artificial intelligence. Then over a period of time, they can operate independently. So now, if you see the some of the self-operating or autonomous robots or autonomous drones, which itself can go and hit a destination in defense area. So some of the leading players in AI ecosystem are Google AI, with Open AI, big companies like Microsoft, then IBM Watson, then Amazon. So some of these leading players, they can channel the research, then framework, the direction wherein artificial intelligence can go. Some of the dominant players, now we'll see the regional trends, North America, like other Africa and all that. So North America holds the dominance of 29.5% on global AI revenue, and some of the R&D, regional excellence like Stanford, MIT, some of the institutions, lot of AI related works are going on. Then funding and all that, like US National AI Initiative Program, like recently also some $500 billion maybe put for AI initiatives. Then India also not falling behind. It is also we allocated more than 200 crores for India AI mission in various critical sectors to propel AI research. So now we see the trend in Europe. Many of the financial transformation, fintech companies or adopting AI, then risk assessments and the fraud detections. So these are all some of the areas. So in fintech AI solutions area, so 4.3 billion in 2023 in Europe. Then regulatory leadership. So EU has come up with an AI Act to establish world first comprehensive legal framework. Similar to GDPR, just we will go in subsequent slides. What is the gist of AI Act? So similarly, GDPR principle which will shape responsible AI development across the region because we have seen earlier GDPR which has some of the principles which includes fairness, ethical considerations and all that. So that is a driving mission for EU AI Act. Then research collaboration for cross-border initiatives, some of the famous ELLIS, which is the Global Research Institute, European Research Institute in this innovation and learning area research. Then by public and private participation in ethical AI area, how it can be accelerated. That University of Helsinki, they are providing free online artificial intelligence and ethical AI course. Like anybody of you interested can enroll and like upgrade your skills in those areas. Like what I see is very good comprehensive course provided by University of Helsinki. So some of the trends in Asia Pacific in our region. We are also a customer adopt technologies like widespread mobile application. When it comes to Asia Pacific, we can say India, Singapore, Hong Kong, Malaysia, those regions. Then they are well in artificial intelligence in the area space of robotic automation systems and all that. Then particularly Singapore and Hong Kong are highly evolved in fintech area for artificial powered credit scoring, risk assessment and all that. Then higher growth is expected in 2030 by this adoption of AI in Asia Pacific region. Then when it comes to various sectors, adopting in healthcare, diagnostic imaging, drug discovery, then in future personalized medicine based on individual human analysis, their DNA, RNA, and all that personal healthcare is possible. Then automotive sector, like self-driving cars, predictive maintenance. These are some of these are already available in Tesla, like some of the cars in Tesla. Then retail development, like supply chain, inventory management, then by visual sets, as I mentioned earlier, capture of pictures, and then providing AI solutions. Then finance, fintech area, systematic investment plan, stock trading, then cyber security, fraud detections, and all that. And when it comes to manufacturing sector, predictive maintenance, quality control, then optimizing supply chain. So these are some of the adoption of AI in various sectors. Then framework for AI development. As I mentioned, data collection and then data privacy and data protection is one of the starting point. Gathering, cleaning, and training AI. Then algorithm development, design and train AI model for specific tasks. So once you feed the data, it can go to autonomous mode also in future. Then deployment and monitoring. Once you deploy it, implementing AI solutions and tracking the perform and feedback mechanism and corrective action. Then finally, testing and validating, ensuring accuracy, fairness, and then robustness of your system. So when it comes to legal regulatory framework in AI, many framework is the focus is testing on responsible and ethical handling of AI. So which involves fairness, transparency, accountability, and the use of human-centric design. So prioritizing human well-being in AI development. Otherwise, there are chances for bias, and then it may go on into autonomous mode. Before going in that mode, the human-centric design is much important to have accountability. Clear, responsible accountability is essential for AI outcomes. Then the transparency in decision making, so which is understandable by all because many of this AI is very difficult to understand background, what is happening, how is happening, how it is going, how it is working, and all that very difficult to understand by a common person. Even to my understanding, even the scientists and all that over a period of time, it is very difficult to explain how it is working. Then ensure fairness uh, for all user groups. Now we will go our area, legal and regulatory landscape for over global overall view. European Union, the key regulations, like as I mentioned, GDPR and then AA Act. It is the primary focus, risk-based approach, then whether the fundamental rights are protected. Then when it comes to United States, NIST framework, AA framework, and National Information Security and Technology, something like that. You Google it, what is NIST? So, and they are having various sectoral laws and regulations. So the US method is fixing voluntary standards and then focusing on innovation. Then comes to China. More or less, the regulations revolve around algorithm regulation. By framing the algorithm, that stage itself they are trying the, like at the design stage, privacy by design. If you see in data privacy, there are some tools which are used by privacy by design. Similar to that, algorithm by design can be incorporated. And then data security law. Their main focus is on national security and then social harmony. So overall, at a global level, with the Organization of Economic and Cooperation for Development, which revolves on AI principles. And if you see UNESCO, which is having a global level AI framework, if you go to UNESCO and uh, search, you will get there UNESCO's global framework on artificial intelligence, which provides ethical guidelines for handling AI and then human-centric approach for AI handling. And some of the recent developments are, because I mentioned European Union AI Act, which is the first comprehensive AI law with risk-based approach, and China's algorithm regulations, and then US executive order to ensure safety standards for AI system and protections for privacy for civil liberties. Then Japan's AI processing, they come up with the international code of conduct for organizations for develop advanced AI system. And then there are various challenges when it comes to AI compliances. Some of the challenges are cross-border data flow and navigating, as I mentioned, data localization requirements and data transfer restrictions. China, when it comes to China and Russia, how to handle this data localization. Like I think in India also, we may stress on data localization. So these are all challenges for the companies. For example, EU restrictions for transferring personal data to countries without adequate protections, which is one of the important areas. Then, because of diverse legal standards and diverse legal and regulatory framework, how to comply. Main challenge is European Union's requirement of explicit consent model and China's natural national security focus. So these both are complementary at the same time having opposite views. Then ethics and social risk, addressing concern about algorithm bias, privacy intrusions, and how it impacts the society. And overall, implementing a robust impact assessment and fairness audit is a global compliance challenge. And then we will try to look into European Union AI Act, which is mainly covers handling data, transparency, how the data is controlled, like the authority, and by oversight, how the overall it can be handled, and then who is accountable, how the fixation of accountability is the main area which global AI regulations of European Union is governing, which is mainly based on risk-based approach. Risk is categorized in three different formats: minimum risk, high risk, and restricted risk, prohibited AI. For example, transparency for chatbot, minimal restriction for low risk, then how the critical infrastructure, medical devices, then HR area, employment tools be governed. This considers some of the high risk area. In other area, like I said, manipulation of records, workplace emotion recognition, like using thumb impression, fingerprint, CCTV, camera capture, how where the camera can be placed. So these are some of the prohibited areas. So high risk AI requirements, some of these are requirements to control data governance, high quality training and bias control, technical documentation, how the AI can be documented and how the performance can be evaluated during audit, then how the overall human oversight, humans can monitor the overall operations, then the system of high risk area, continuous monitoring and providing risk mitigation solutions. Then generating AI provisions. These are some of the evolving areas. Like transparency requirements, disclose AI generated contents, documenting training data sources. Of course, documenting is a very difficult task. I don't know how it is going to be implemented. Then copyrighting the complaint requirement. Like if there is any innovative concept like coming into the way, how to respect intellectual property rights in the innovation area, like how patent can be generated on those area, how patent can be provided in those area, and maintaining detailed summaries of protected work. Like as I mentioned, whether you can protect it by copyright or trade secret or patents or know-how. So those, as of now, we are like still not aware how these provisions can be incorporated. Then risk assessments to mitigate risk. So how we come up with legal and regulatory assessment. Similar to that, how artificial intelligence risk assessments can play. And when it comes to European Union, already they are in the verge of implementation. February 2, 2025, they had some protected practices and general provisions which can apply in European Union countries. And then August 2, 2026 is the applicability for implementing high risk requirement. And then now it is ongoing regulatory guidelines and regulatory guidance, and then the enforcement mechanism. And yeah, in that legal requirements, if there is any violation, fixation of fine up to 35 million euros, then 7% of global revenue, and there are more than 27 national authorities for enforcement of this AI. Then there are sandboxes available, which is like since AI is an evolving area, sandbox provision for regulatory testing. These are some balances for evolving at the same time to enact AI regulations, SME support, then having AI excellence, center of excellence for observing best practices, technical assistance, like in India, IITs like that. Then these are some of the plan of action for the company, AI inventory, gap analysis, implementation plan, documenting robust record keeping system, then just these are some of the last slides. AI landscape overview in India. The Niti Aayog has come up with India national AI strategy. I had taken some of the points from this Niti Aayog's AI framework only, which is in the sector, healthcare, agriculture, education, infrastructure, and supply chain and transportation. That's supporting more than 2,000 AI startup for transforming. Then there are robust academic research by Indian Institute of Technology, Indian Institute of Science, and I consider this our system, our then the Sambhav also is helping and supporting legal and regulation, how it is evolving, and how we can help in spreading the knowledge to various sectors of society. And then we can come up with a legal, robust regulatory framework in India The current framework, as I mentioned, some of these are information technology and personal data protection bill, like the DPDP, then Consumer Protection Act, then emerging technologies and regulations by NITI Aayog, that framework ECC. Its main principles are focused on safety and reliability, equality and inclusion, privacy and security, transparency, accountability, and explainability. And some of the requirements are data localization, consent framework, sector-specific regulations, as I mentioned, healthcare, finance, e-governance, and it is by questionnaire format, impact assessment, data protection impact assessment, data privacy impact assessment, and categorizing by high risk application and all that, which will help key takeaways in global growth. We can anticipate 35.9% CAGR in future, regulatory evolving, because we can't say what is going to happen now, this evolving system. But India's position is very strong as an emerging, a significant player, and we can collaborate in future with various industry, government, and academia. So in short, these are some of the things. Like I think I had completed by overshooting 3 minutes. Sorry for that. I hope my presentation was giving a global overview of framework on both data privacy as well as artificial intelligence. Thank you. I
Thank
have
you very much,
stopped
Mr.
sharing.
Ganapathy. Yeah, thank you very much. Participant, if any question query, you can unmute yourself. There are a couple of questions. It's also there.
Yeah,
Sir,
due
could
to
you please?
faculty of time, yeah. Like I will restrict questions just one or two only. Rest anything, you are free to reach out to me. Like I will reach out to the person.
Okay. So, what is a practical recourse for a data breach by company in India?
Data privacy risk, like as of now, since the law is evolving, there is the way of fine, penalty, in worst case, like according to the law, criminal and civil, both is available.
And which are the best website to study international perspective on application of AI in the legal field? Any
Yeah, as I
platform?
mentioned, I will take that University of Helsinki. That is one of the best. Like I will just type. You can Google it and try that.
Okay. Good. So we should close as per your request. So participant, you can search in this Google University of Helsinki related to AI related course. So thank you very much, Mr. Ganpati, for your insightful lecture. I would
Yeah,
say you covered both the aspect and then greatly mentioned and discussed the international aspect from evaluation and then what's going on right now and then what will be the way forward. So I
yeah.
hope
Thank you very
participant.
much.
Yeah, thank you.
Yeah, since this is a Sunday, I don't want to give more stress to the participant. But
Yeah, sure,
anyhow,
sure.
anytime they are feel free to reach out to me. I provide my personal email
Sure,
ID also.
sure.
Yeah, thank you.
Thank you. Thank you, participant, for joining. See you tomorrow.